Welcome, everyone, to Voices of NCAJ, the podcast for the North Carolina Advocates for Justice. I am Amber Nimocks, your host and Director of External Affairs for NCAJ. Before we get started, I'd like to thank today's episode sponsor, Advocate Capital. Advocate is passionate about helping plaintiffs' attorneys get better results for their clients, mainly through their AdvoTrack case expense funding service. It allows firms to track case expenses and recover borrowing costs, which makes the net cost of borrowing zero on cases they win. And you can learn more about that at advocatecapital.com. I am excited to welcome today's guest, Ian Mance. Ian serves as senior counsel for Emancipate NC. He has worked for almost 20 years on criminal and racial justice policy and litigation in North Carolina for organizations including the ACLU of North Carolina, the Southern Coalition for Social Justice, and the UNC School of Government Public Defense Education Group. Ian played a key role in the adoption of policies designed to curb discriminatory stop and search practices in a number of the state's largest cities. In 2013, he received a Soros Justice Fellowship for his work developing mechanisms for lawyers to identify and challenge racial profiling in traffic enforcement. Ian will be presenting at NCAJ's upcoming Criminal Defense CLE on how to use a traffic stop database in litigating criminal cases. That CLE will be Friday, December 13th, and you can register and find more information at ncaj.com/events. Ian, welcome to the podcast.
Thank you for having me.
First, tell me about the upcoming CLE and the database that you will be discussing.
Sure. Well, this is maybe the third or fourth seminar I've done, or CLE, through NC Advocates for Justice, going back to maybe 2013. And this CLE will build on those past presentations, kind of give a refresher on how lawyers can access data on the enforcement patterns of individual police officers, and also how this data has been introduced in state and federal courts in North Carolina in support of selective enforcement claims, or what's commonly referred to as racial profiling.
Mm-hmm. And what's the name of the database? It has a specific name, right?
Well, there's a couple different ways to access the database. It's
Okay.
really, it's housed in the State Bureau of Investigation, and it's data that is generated pursuant to a North Carolina general statute, which is 143B 903. That database is now online. There's two different websites that are interactive websites. One is opendatapolicingnc.com, which was a site that I had developed when I was at the Southern Coalition that went public in 2015. The other is a more recent site, nccopwatch.org, which is administered by Forward Justice, which is another civil rights nonprofit here in Durham.
Mm-hmm.
So people can access the database through either of those platforms. Since my last CLE, the state has transitioned away from ACES, which we've used for 40 some years for our criminal records, to the new eCourts and Odyssey system. So one of the things that I'll be talking about in December is this transition and the new protocols for finding officer ID numbers and their stop patterns. Last year, the Supreme Court of North Carolina also decided a case called State versus Johnson, which was the first appellate case to consider the use of this data in a defense context. And Johnson clarified some things, but also created some new evidentiary hurdles for defenders, particularly in large cities with multiple police patrol districts. So that's something that I'll be speaking to at the CLE. Since that opinion came out a little over a year ago, we've been working with data scientists and technology experts to develop solutions to the problems that were confronted by the defender who was litigating that case. And so this CLE is aimed at informing attorneys about these recent developments over the past year and to arm them with new information that hopefully will allow them to be successful in bringing these claims in the future.
So it's some real hands-on how-to stuff that you're going to be giving to criminal defense attorneys at this CLE.
It is, but it's also sort of designed to just continue to let people understand that this information is available in North Carolina. A lot of people still are not aware of it. It's a kind of a unique law that we have in North Carolina. We were the first state to pass such a law. And so part of it is just orienting people to the idea of using this data in their casework. And we will take them through the nuts and bolts of how to get it. If they still, after an hour, encounter difficulties doing that, people can always reach out to me, and we're always able to help them sort of navigate the database if it's their first time using it. So you don't have to, um, you may not come away from the CLE with a full understanding of the technological side of things, but we'll certainly always be available to help people work through those on a case-by-case basis.
Mm-hmm. So North Carolina was the first in the country to pass. What law was it that made this possible?
So it was passed in 1999, so 25 years ago now. And it started collecting data for the Highway Patrol on January 1st of 2000, and for all the other agencies in North Carolina, January 1st, 2002, all agencies that serve a population of greater than 10,000 people. And it was, according to sort of the newspaper accounts from 1999, it was inspired by, or was introduced in response to concerns about a series of articles that had been written about drug enforcement, highway interdiction in Fayetteville and Cumberland County, and the racial disproportionalities of the searches that were occurring down there. And so I think that was the animating force behind the law, was to get a better understanding of to what extent is this phenomenon happening in other parts of the state. And so again, this law was passed. In more recent years, a lot of states have sort of followed North Carolina's lead, and so many states now have these laws, but none have had them as long as we have, and most do not have as robust a data set as we have. Our database currently, last I checked, had over 36 million traffic stops. And these are very detailed traffic stops. You can imagine a kind of an Excel spreadsheet that's 36 million fields down and 41 tabs across. And so for every traffic stop that's occurred, we collect the reason that the traffic stop was made, the race of the driver and any passengers that were in the vehicle, and then anything notable that happened in the course of the traffic stop. So did a search occur? If so, what was the lawful basis of the search? Was it a consent search, a probable cause search? Was contraband found or not found in the vehicle? And if so, what was found? Was use of force used in the course of the traffic stop? And if so, was the force initiated by someone in the vehicle or by the officer? These are the sort of things that we collect in North Carolina. And officers fill this out on a computer in their car at the conclusion of every traffic stop. Their data gets aggregated every month and relayed along with all the department-wide data to the SBI, which holds it in this database. So we've been doing this for 25 years. It really wasn't until 2012 that this information began to be explored, because prior to 2012, it was kept in a format that was just completely inaccessible to anyone that didn't have access to, a supercomputer to sort of load these databases given their size. In 2012, Dr. Frank Baumgartner at the University of North Carolina became one of the first researchers to really dig into this data set and run the numbers and publish some preliminary findings. And I was in law school at UNC at the time and got connected with him, and that was sort of my entry to this issue. We published some preliminary findings actually in the NCAJ trial briefs back in 2012, which was, I think, the first sort of public reporting on what the data showed. And what it showed, and what it continues to show, is that across North Carolina, Black drivers are about twice as likely to be stopped and about 3 to 4 times as likely to be searched, kind of all things being equal. And that this is a pattern we see pretty much statewide, and it's has persisted and in fact gotten worse over the years, despite the fact that we have, really compelling contraband seizure data that suggests that people of all races are essentially driving around with contraband at the same rate in their cars. We know this from the Highway Patrol data, which patrols the entire state of North Carolina and has been collecting for a full 25 years. And so, that's what the database includes, but it also includes officer data on an individual level. And so what we've worked to do over the last 10 years is make that individual officer data accessible to attorneys and community organizers and public officials and law enforcement executives and people who might have use for it.
Mm-hmm. So for individual criminal defense practitioners, how has the utilitarian value of this database evolved over time?
I would say that since 2013, lawyers have been using it in support of motions to suppress. I'd say that's the primary use for it in court. There's been this parallel effort in city councils around the state, which I've also been involved in, to get policy changes at the local level. But for defenders, normally the data is offered either by way of an affidavit or testimony. Often I'll submit an affidavit and then be called to testify to the data in a motion to suppress hearing. The first case I did that on, which is a case called State v. Corral that was in Orange County in 2013, involved a man who had, I think, the biggest drug seizure in the county that particular year. He was a Mexican national. There were some concerns from his appointed defender about the officer's claim that he had given consent to search the vehicle because he didn't speak English and they didn't speak Spanish. And so that prompted her to reach out to me to try to find these officers' data patterns. And when we found them, what we saw was that they were stopping almost exclusively Hispanic drivers and had been doing that for years in a county where the Hispanic population was 6 or 7%. And that for every one driver that they were finding contraband on, they were searching, upwards of 90 to 95 drivers who did not have contraband on them. And that was a really compelling data, and to this day, still one of the more dramatic examples I've seen, in a case. In fact, when you took these two officers out of the statewide data set of 10,000 officers, it actually shifted the statewide Hispanic search rate by a fraction of a percentage point. That's how high volume they were. And so in that case, this man who was facing essentially a life sentence given his age was offered a plea before the judge could enter his ruling on the motion to suppress. The judge had reserved his ruling. And in that case, he was released to time served. I do believe he was deported, but I think he was very happy to have that outcome. And it had this cascading effect of having the prosecutors then went and looked at other cases that were presently charged by those same officers, and a number of those cases were dismissed just entirely because of concerns about the officer's testimony. So that was one example, and that's an example I often use to try to illustrate to folks the power of this data if in the right case, and it's not going to be most cases that you're going to get an outcome like that or have data that dramatic, but sometimes you will stumble across that in your practice, and when you do have data like that, it can be really effective in helping to resolve the case.
Hmm. And you mentioned earlier that Supreme Court of North Carolina recently decided State v. Johnson, and you'll be talking a little bit about the implications of that case. Is there more to say on what kind of guidance you can give attorneys in light of that?
Sure. Yeah, I think I'll give a little context for State v. Johnson. So this was a criminal case that started in 2018. It was a case I testified in at the trial court level in a motion to suppress hearing that was brought under the Equal Protection Clause. The arresting officer in that case took the stand after I did not dispute the data I had introduced about him, which showed that 82% of his traffic stops in his career had involved Black drivers. And this was in the city of Raleigh, which was at the time, I think the Black population was 28%. And he did not dispute the accuracy of the data, but he did testify that he was assigned to the Southeastern District. And that testimony that he was assigned to the Southeastern District became a real issue on the case on appeal. The judge denied the motion to suppress, and then so the defendant appealed. And the question on appeal was, what is the proper benchmark for comparison for this officer's data? Raleigh is a city that had multiple patrol districts, and some of the patrol districts, including the Southeastern, had a higher Black population than the city as a whole. So that became a concern with the court is, can we really infer discriminatory intent? The court acknowledged that the disparity between the officer stop patterns and the city data was stark, which is the word they often use when they find a selective enforcement violation. But they ultimately did not find a selective enforcement violation in this case because of the lack of information about the population within the patrol district to which that officer was assigned. That is an issue that we have to confront moving forward in cases in cities like Charlotte and Raleigh that have these multiple patrol districts. One of the things that I will be presenting on at the CLE is the solution that we've come up with for that problem. We actually were able to engage with some epidemiologists at UNC Chapel Hill, including Dr. Mike Fliss, who wrote his dissertation on this very issue of how to estimate the population of police patrol districts. So we have an expert here in state who actually briefed the Supreme Court in Johnson and continued to work on that problem, and has developed a technological solution such that we now actually have, for all of the patrol districts in Raleigh, pretty precise demographics of each of those districts. That's something we didn't have in 2018 when Johnson was being tried, that we could introduce today that would really speak to the court's main concern. The other thing that I'll be talking about is, in Johnson, the officer testified he was assigned. So he took the position that he was required to kind of not go outside of these district boundaries. And so then the question a lot of people wanted to know afterwards, was that true? And at the time, we didn't have a mechanism to objectively determine whether that was a true claim or not. We've since developed a mechanism to do that through the use of an additional data set that's maintained by the FBI, and now can sort of ahead of a hearing sort of interrogate this question of whether an officer has the freedom to roam around the city, in which case the benchmark number becomes the city population, or if he's confined to a particular district, in which case we know that we need to focus in on the population numbers for that district. And so that's a new technique that we've just kind of figured out in the last couple of months that we'll be presenting in December.
So you said another reason that you're doing this CLE is just to raise awareness of the fact that the database exists and that people are using it with some amount of success. Do you know anything about like the user, the rate of use? I mean, what sort of education gap is there that like people, that criminal defense lawyers need to be better informed about this?
Well, I think that every year since 2015, the end of 2015, when we put this online, I have heard from more and more attorneys. So the word is getting out. I often hear about people using the website that we developed kind of after the fact. I mean, part of the idea of putting it online was to take myself out of the process, because from 2013 to 15, when I was doing this work, the database was not online, and so everyone would kind of come to me, and I would be the way they would both find the data and introduce it. Putting it online, the idea was kind of to make that unnecessary, and we've done a number of trainings at NCAJ, and there's a lot of attorneys who are now accustomed to using the website, finding officer data without needing to call me. And so I'll often hear about it after the fact and say, I was able to get a case dismissed when I just printed this page from the website and showed this data to, in fact, one told me recently that they had printed off the officer data from an arresting officer in one of their cases and presented it to an ADA who looked at it and responded and said that they were going to be dismissing the cases because the data confirmed some concerns that they had already had about that particular officer that they hadn't shared or at least spoken of previously. So I have a sense that, more people are using it that I personally hear about. In the course of a given year, I'll normally consult on 5 or 6 cases. They tend to be in the bigger cities. That's where I get calls from the most. And in recent years, there's been a lot more interest from the federal defenders, particularly in Charlotte, who've had us down to do some trainings and who I know have made good use of it and gotten some good outcomes in the last couple of years for their clients.
And the project, sort of all the work that you've done since 2012, this has been praised not just by criminal defense attorneys, but you've also had some good testimonials from law enforcement officials. How are they using it and responding to it?
Well, yeah, there have definitely been some police chiefs who have embraced it. I don't want to overstate how many, because at the same time, I got to acknowledge there are police chiefs that don't like this information being as widely accessible as it is here. But yes, when we launched this event or this website at an event in 2015, the Fayetteville Chief of Police, Harold Medlock, who's since retired, came up to Durham and was one of the key speakers at the event. And he was there really to make the case that police should embrace this, that it was something that he had embraced within his department, that there's really no good public policy reason for the police not to be transparent about who it is or that is being stopped and searched and arrested. That is appropriately public record, and it is something we should appropriately scrutinize. One thing that I often share with police chiefs, and that Chief Medlock, I know has shared with a number of them, is that, I'll tell that story like the one I just did about this case being dismissed that was a pretty significant case, and say, wouldn't you rather know about your officer's stop data before it's used by a defense lawyer in court to get, a case that you care about dismissed? And they'll always say, of course I would have rather known that. And so I'll say, you can use this website to proactively monitor your officers. You can incorporate using this website into performance reviews. When you sit down quarterly to do your review commendations and complaints that might have come in, you can pull up this website, look at the officer's data. Where that officer's assigned and what the demographics of that area is. And so you can do a comparison. And if something looks amiss, you now have an opportunity to engage with that officer and have a conversation that might sort of change how they operate moving forward. And when you lay it out like that as sort of a way that chiefs can get ahead of problems, they are more inclined to embrace it and make use of it. So I don't know how many are actively using it month to month. It's something I always encourage chiefs to do when I meet with them. And I know certain cities like Fayetteville certainly have made use of it in the past.
Mm-hmm. And you've been involved in working with a number of police departments in developing policies that look at the stop and search practices in their departments, right?
Mm-hmm. Yes, yeah. I've been involved in, efforts in Asheville, Durham, Chapel Hill, and Greensboro are kind of the big four that I've engaged with. And we've had varying degrees of success, and the approach in each city has been different, and sort of the way we engaged has been different, and the policies that we've sought have been different. In Durham and Asheville, there was a lot of community engagement, specifically around this idea of written consent to search policies, which is requiring officers prior to searching a vehicle in the absence of probable cause, and if they are relying on consent, to get that consent in writing and to present a driver with a form with city letterhead that tells them that it's their choice, and that if they choose not to sign the form, that their rights will be respected and their car won't be searched. And when you have that policy in effect, in Durham especially, has made a real difference in the rate at which people are searched. And in the 5 years after that policy was implemented in Durham, the searches citywide were cut in half. And so that had a really dramatic effect there. In Greenville, and that came about more as a result of a sustained community organizing campaign, and a lot of people who were directly impacted by these stops and searches coming out to City Hall and getting behind a microphone and speaking directly to City Council about their experiences. And then, we came in with the data side and sort of put those experiences in this broader context of this larger phenomenon of traffic stops and searches in Durham, and then identified some policies that we thought would mitigate those problems, and we're able to get that done. In Greensboro, it was very different. We went a different route and pitched the New York Times on the Greensboro data around vehicular and regulatory based stops. So these are stops for non-moving, non-safety reasons. And we're able to illustrate that these stops in Greensboro, but also in many cities around the state, are highly racialized in terms of just the numbers of who's being stopped. That the Times ended up running an expose on those numbers that prompted the city there to, for a period of a year, prohibit officers from making those types of stops. And during that year that they did that, the stop disparity between black and white drivers dropped by double digits, which is unheard of, frankly. That I'm not aware of any other city that's kind of had that sort of shift year over year. And then there have been cities that have done sort of a more watered down version of a written consent policy, like the one in Durham, that has some exceptions. So there's been a public policy component to this traffic stop work as well. It's not all been sort of in the courtroom.
Wow, that's impressive. Double-digit drop is unheard of. So the incoming presidential administration has a stated platform regarding stop and frisk, and it's very aggressively in favor of it. Do you have any concerns related to, the use of this traffic stop data going forward, and how it will be interpreted in a new context under a new administration? Will that have any effect on the work that you're doing, or how it could be used? I know it's all speculative at this point.
Well, I have a number of thoughts. I mean, One, I'm glad that we have access to this data in North Carolina because I think it may become more necessary in the coming years if that does come true. I'm very concerned, I think, like many people, about where we might be headed, particularly if the federal government has been discussed starts utilizing local law enforcement in service of some, deportation program or something like that. I think also that having an executive who sort of uses the bully pulpit to endorse heavy-handed police tactics does give a certain license to officers to engage in behaviors that they might not otherwise would, even if they're not federal law enforcement officers, just sort of culturally gives them that okay. And I think that it could get ugly, which is why we need the defense bar to continue to think creatively about using every tool in our toolbox, and this is one of them. I will say I was just in court not that long ago in front of a Trump appointed judge in a sentencing hearing testifying to an officer's stop data, which was the defender made a very creative argument about sort of procedural justice. And even though that particular client was taking a plea, she believed that the way that he came to the state's attention was a result of a racial profile, and that the sentence needed to reflect that, and that the judge should downwardly depart because of that. And that judge did downwardly depart significantly in that defendant's sentencing. I don't know specifically if that was because of the data, but that was certainly a big part of the discussion. The judge did remark on the record that he found the officer's stop data to be disturbing. So I think that even we have had some instances where judges that we might not have expected to be receptive to this data have been.
Okay. So your best advice for criminal defense practitioners is to use the data and be creative?
Well, and I would say get in the habit of just, especially if you get a case arising from a traffic stop or a vehicle, take a few minutes on one of these websites and take a look at the officer's data. Just kind of get in that habit. In North Carolina, the main way that people interact with the police is in the context of a traffic stop. I think slightly over half of our police citizen interactions are traffic based. So a lot of time you might pull up this data and it won't pop and you move on to something else. But in some instances, the numbers will leap off the page and can be a potent negotiating tool or advocacy tool, and can make your case a lot easier. And so I would say to them to get in the habit of doing that in cases involving vehicles. And I know that the process can be a little confusing for people who haven't been through it before. So again, reach out to Emancipate. It's sort of like a service we provide to the public and to any attorney who's interested in getting the data. If you can't find the data yourself, we will help you find it. So I guess that's what I would encourage people to do.
Okay, great. And we'll put all the contact information that folks need, I guess, to reach you at Emancipate, and how to take a look at the databases themselves in the show notes as well.
Great.
Terrific. Well, Ian, thank you so much for being on the podcast. And thank you so much for presenting at the upcoming Criminal Defense CLE.
Well, thank you for having me, and I'm looking forward to it.
Great. Ian will be a presenter at the December 13 Criminal Defense CLE at NCAJ headquarters. You can attend in person or virtually. And to find out more information about the CLE and to register, go to ncaj.com/events and get signed up. Thanks, everyone, for listening.